Does a burglar alarm give you agency to enter a house, to clear it, and so forth? My name is Anthony Bandiero. I'm an attorney for Blue Gold Law Enforcement Training, bringing you another Roadside Chat. This officer is in Colorado. He says, I took your class a few years ago, and maybe you're talking about burglar alarms. He believed that I said that, generally speaking, alarms do create agency to clear the house and so forth. But now he's being told that the alarm alone is not enough. Okay. Well, first of all, he did say this has been a few years. Case law has definitely changed or been, updated on some principles in the last few years. But generally speaking, when it comes to like entering for alarm systems and so forth, a lot of courts have given cops qualified immunity and said it's not clearly established that they can't, enter backyards or into home, into the home on the response to a burglar alarm. However, one thing that I have, made clear in my training, at least I try to, I shouldn't say that, but I try to make clear is that I really want alarm plus, right? I want alarm plus other factors. I do not think it's good at, and going into the backyard may be okay. Like going into the backyard is less intrusive than going into the house. But I'm just saying, I'm not going to just walk into a house without, just because of an alarm. People, the vast majority of burglar alarms at homes are false. I'm talking 90-something%. It's the neighbor taking care of the dog. He forgot the code. It's the drunk homeowner coming home at night, whatever it is. And then, the worst case scenario is having that armed confrontation with somebody who's lawfully allowed to be there, and all you have was a silent alarm or so forth. So I don't recommend at all that you go into that house and clear it unless you have something more. And the officer is correct that in Colorado, at least in the 10th Circuit, you're going to need something more than just a silent alarm. And the case there, pull it up here, is U.S. versus Martinez. It's 10th Circuit, 2011. Now, Martinez also references a 10th Circuit case called McCleod. But regardless, if you find Martinez, you can find these other cases. So we're going to compare two cases. We're going to compare Martinez with McCleod. Now, they talk about McCleod in this case because in McCleod, they actually upheld entering the home, sweeping it, looking for people in people-sized places, and so forth. But in Martinez, they did not. Here is what they say. They said the United States relies heavily on cases in which the activation of home alarms help to create exigent circumstances for police to enter the home. But only one of these cases, which is McCleod, a case from the 10th Circuit 2006, is binding authority on our court. Yet the facts of McCleod are entirely distinguishable from those that occurred here. In McCleod, the alarm at the defendant's house had activated, and the individual answering the resident's telephone did not know the security code for the alarm, which suggests an unauthorized person was in the house. Moreover, when the police arrived, the officer was confronted with two people who were unusually dirty in appearance, did not have any form of personal identification, were admittedly not the homeowners, did not know the name of the homeowner, and were acting in a nervous manner. Further, one of the two people was observed leaving the residence, did not speak, and acted disorientated. Thus, although the home alarm initially drew police to the house, there were plenty of substantiating facts to create an objective, reasonable belief that the burglary was in progress at the house. Now, what usually happens in these cases, and the reason why we're probably even talking about it, is that if the homeowner was actually like, if like these people don't belong there, they're probably trying to rob a drug house. But if they were like regular burglary suspects and they got caught, then we wouldn't, like, you would have a case against the suspects. You wouldn't have a case against the homeowner, which McCleod is likely going to be the homeowner. And he's saying, oh, you don't have enough reason. That's not enough reason to go to my house. Because what happened here is you go into the house and then what happened, right? You see drugs, stolen property, whatever, in plain view. And you find out later that these two unkept, people are trying to rip McCleod, right? Well, the cops clearly had an objective reason to believe that there was an ongoing burglary. So that's kind of like what happens in these cases. Again, if the McCleod was a legitimate, person who was not engaged in criminal activity, and the police just arrested people trying to break into his house, he would have been given high fives, right? Not condemnations. Now, here in Martinez, this is what the court said. They said that, however, here, the officers saw no evidence that unauthorized individuals were in the house or that anyone was in the house at all. The officers did not hear or see anyone in or near the house. They saw no signs of forced entry. They saw no cars near the house. The gate to the property was closed. None of the officers' observations created a reasonable belief that there was an emergency inside the home. Excellent, okay? Share this video because this is exactly what I'm talking about when it comes to making good case law. We know that most of these home alarms are false. It's the homeowner tripping the alarm or the friends. So the more intrusive you're going to be, the more articulation you should have. So if I misrepresented that, back when I had the class in Colorado, I apologize. Again, generally speaking, cops can get some qualified immunity here. But when it comes to making good case law, when it comes to articulating this and being on the right side of the law, articulate it. Articulate why you believe that this alarm could be legitimate. All right? All right. I will give you one more case, though, which is it's like Bilida versus McCleod, First Circuit 2000. This is a case about going into the backyard on the burglar alarm. Again, generally speaking, I think it is appropriate and reasonable to, like, as you're outside the home looking for signs of forced entry and so forth. But a lot of cops do want to kind of clear the backyard to see if there's that broken window and so forth. I think that's appropriate, right? Because you can't really effectively clear that call unless you see 360 around the house. Use good judgment. Hopefully get a hold of like the homeowner and so forth, but kind of go from there. All right? All right. Thanks, guys, for listening to this video. I will talk to you next time. And just remember, make good case law.